Hear ye, hear ye. The Court of Appeals for the First District of Texas is now in session. Pursuant to adjournment, God save the Constitution and Son of the Court.
Good afternoon and welcome to a virtual session of the First Court of Appeals in Houston, Texas. We have but one case on today's docket. Case number 01-20-00287-CV, City of Pasadena, Jeff Wagner and Robin Green versus APTVV LLC and APTPCY LLC. I have the appearance of counsel, please. First, the attorney for the appellants.
Good afternoon, Your Honor. William Halfand for the City of Pasadena.
And I understand you'll be reserving 5 minutes for rebuttal.
If I may, please.
And attorney for the appellee.
Yes, Your Honor. Robert Gibson here for the appellees.
Okay, thank you very much. Now, as soon as Mr. Gibson disappears from the screen, Mr. Halfand may proceed.
I beg your pardon, Your Honor. Did you want me to wait for Mr. Gibson to disappear?
Get there. Yes, when he disappears, now you can go.
Thank you. May it please the court, William Halfand for the City of Pasadena, Mayor Wagner and Mr. Robin Green. Let me start with what should be a brief discussion regarding the individual defendants and a claim of ultra-virus. The trial court clearly erred in failing to grant the plea to the jurisdiction as it relates to the claim of ultra-virus because there is simply not even an allegation by which a court could find that the elected mayor of this home rule city or the city's chief engineer could have acted without legal authority or failed to perform a ministerial act. The plaintiff's appellee's pleadings are clear. What they complain of is that the city passed an ordinance which grants a franchise to Waste Management, by which Waste Management collects refuse within the city, consistent with Health and Safety Code 364.034. That's not disputed. And if that's the case, there can be no assertion that the mayor or any executive branch employee of the city acting individually failed to act with legal authority or to perform a purely ministerial act. Mr. Green has no authority over the passage of the ordinance, merely its administration. And the mayor, equally under the city's charter, has no individual authority to enact the ordinance or to refuse to sign the ordinance once it was passed by council. The analog here is cited in the briefing, the City of Bedford versus Apartment Association of Tarrant County case 2017 from the Court of Appeals in Fort Worth, in which the court pointed out that—
Mr. Halfand,
yes, Judge.
Rather than discussing ultra-virus, let's go to the issue of standing. And you cited with a CF site, Nivens versus City of League City. Could you please discuss how City of League City applies to this case and the extent to which we are bound by it?
Sure, Judge. Well, Nivens really doesn't apply to this case. Nivens, except to the extent that it demonstrates a lack of standing. The Nivens case, of course, as the court will recall, dealt with the assessment of taxes, not fees. And the appellees in this case have pointed to the Terra Partners versus South Houston case from the 14th Court of Appeals, which addressed the Nivens holding in terms of a claim of a coercive or duress type payment. But of course, Nivens dealt with the issue of taxes. More importantly, at this point,
what is the analytical distinction between a tax and a fee, and how does that affect standing?
Well, in this case, the tax is one that's clearly assessed directly by the government. Here, the fee is authorized by statute. Under the statute itself, Section A3 specifically authorizes, the legislature has granted the city the authority to assess a fee for this very service. And that's the first place in which the appellee's claim fails, because the assertion is that the city cannot charge a fee, yet the fee is statutorily authorized. And the city at record 98 through 105 presents evidence of the basis for its fee in the exercise of its police powers. And there's no dispute in the record as to the necessity of those fees. Now, I would be remiss if I didn't acknowledge that, in fact, the city does not claim to be assessing a separate fee, although the statute authorizes it to do so. And here again, the record is undisputed as it relates to Mr. Losa's declaration, which is at record 149 to 150. The sole evidence on the issue of what the 25% number that's identified in the bill that the appellees receive actually is. That is simply, as Waste Management explains, an identification of that portion of Waste Management's fee that it's required to pay to the city under the franchise agreement. Because the appellees are not parties to the franchise agreement itself, they lack standing to address the propriety or the terms of that contract itself.
Mr. Helfand, let me ask you a related question. Is money had and received a contractual claim? And if it is, what is your authority for that?
Well, money had and received, I would respectfully submit, is a quasi-contractual claim. Obviously, money had and received, some courts have defined it as a tort. Some courts have defined it as quasi-contractual. I've not seen an interpretation that it is a contract claim, but it would be barred under any such theory. Let's start with tort. Well, obviously, if it were a tort cause of action, it would be barred by the Tort Claims Act. There's no waiver under 101-021 for a tort of money had and received. As to contract, if it's a contract claim, it's barred by the lack of a waiver within 271-152 of the local government code. As the San Antonio Court of Appeals identified in the Lower Colorado River Authority versus City of Bern case, which is cited in the briefing, the legislature's decision to expressly restrict the waiver of immunity for contractual claims under 271-152 to goods and services received by the governmental entity is an identification that the legislature consciously chose to exclude other contractual and quasi-contractual causes of action. This court cited with approval that holding in, let me find that site, in the National Public Finance Guarantee Corp case versus Harris County, 448 Southwest 3rd 472 at page 484. So whether it's, Your Honor, contractual or quasi-contractual, as the court pointed out in the Lower Colorado River Authority case, Lower Colorado River Authority versus Bern case, there is no waiver of governmental immunity for a cause of action for money had and received. And that, of course, is the crux of the problem. But I don't want to use up all of my time if I've answered Your Honor's question, Justice Landau, without pointing out that, as I said, the record here is essentially undisputed. And the appellees present no evidence in the record that refutes nor do they cite any authority that refutes the city's authority under 364.034A3 to charge a separate fee if the city were so inclined. But the city doesn't even claim to charge, and as I said, record 98 through 105 demonstrates the basis for such a fee under the exercise of the city's police powers as authorized by the statute. But moreover, the record is undisputed in Mr. Losa's declaration at 149 and 150 that the city does not charge a separate fee, but rather extracts a fee from Waste Management through the franchise agreement itself. And In fact, that's also in the agreement itself at record 106. The agreement specifically provides that Waste Management, not the customer, must pay a 25% fee for the services that Waste Management provides. Now, obviously, Waste Management doesn't pay that out of anything other than the fees that Waste Management charges to the customers, but that fee is authorized by 364.034 as well. So, and the last thing, and maybe this also addresses, in a brief time I have left in the opening, Justice Landau, this may address the issue as well, and maybe addresses Justice Kelly's question regarding standing under Nivens or Nivens, I'm not sure of the pronunciation. All of that predates the Texas Supreme Court's opinion in Sharyland Water Supply versus City of Alton in 2011, because those cases really speak to a question of waiver by conduct or some type of equitable waiver, which, as the court knows, in 2011, the Texas Supreme Court expressly renounced. And we are now in an era in which, long after those cases were decided, that only the legislature may waive immunity, and the appellees point to no legislative waiver.
All right, thank you very much, Mr. Helfand. Mr. Gibson, you have 15 minutes.
Thank you. May it please the court. The appellees are required to plead facts supporting jurisdiction. And as shown in the brief, sufficient facts have been pled. Mr. Helfand mentions evidence in the record. It's our position that to sustain the court's order of denial of the plea, all we have to do is plead facts that show that the court has jurisdiction. The trial court looked at those facts as pled, assumed that they were true, as it's required to do, and properly denied the plea. The bottom line is that no matter how they word it, my client was charged, when this case first started, 10% per month for trash collection. During the course of this lawsuit, it went up to 25%. And then as shown in the brief, between the time that this appeal was perfected and April the 24th, I believe it was, the city took their fee back down to 15%. Don't know why that was. We weren't able to plead that fact or even discover that fact since the case was stayed by this appeal.
Did the city have authority to increase the fee?
Well, I guess it depends on what authority means. It's our position that under the Constitution, no, they did not. Well, to the degree that they increased it. They got to show that there's a reasonable basis for the fee that's charged. That's kind of the foundational requirement.
Is it really the city's burden of proof to establish that? Or is it your burden as a plaintiff, assailing it, to show that it's unreasonable?
I think it is my burden, Judge, to prove that. One of the problems in this case is...
Then beyond that, do you have to plead particularized facts establishing that it is unreasonable? Like, what do other municipalities charge? What is the industry standard for it? Is it enough that you just say it's unreasonable, or do you have to plead facts to establish it's unreasonable?
I don't know of any case law, Your Honor, that requires us to plead specifically. The fact that we have pled that
can it be just a featherweight standard? Can you just say it's unreasonable and therefore we have the right to sue? Or do you have to have some particularized pleadings, some particularized facts to establish that it's unreasonable? Otherwise, anybody could sue about any tax and say, a 1% fee is unreasonable when everybody knows that it's not. So what facts do you have to plead? What is the burden of pleading to go forward with this?
I guess that's a $64,000 question, Your Honor. I'm not really sure what that standard is, if there's a standard. I'm not aware of any case law that spells that out. And I'm not saying there isn't any. I'm just not aware of any.
Well, there's the general requirement. The plaintiff has to plead jurisdictional facts. And simply saying that the fee is unreasonable, that's sort of reciting the standard. But you're not pleading any jurisdictional facts to support that the city has violated that standard. So where do we look for facts in your third amendment petition that establish that the fee is unreasonable?
I guess, Your Honor, to respond, I would say the fact that they went from 10% to 25%, that my client was being charged about $1,300 a month just for trash pickup.
You know, what if League City charges 50% fee for the same thing, and actually 25% is cheaper than League City is charging?
Well, does that make it reasonable? If everybody speeds, does that mean everybody can avoid the speed limit?
Where are the facts establishing that? What yardstick is there in the petition that we can judge reasonableness?
There's not any in the pleading, Judge, to say that the city of Houston charges a flat fee of $900 a year per truck. There's not. Now, I would suggest that we haven't been able to do discovery in this case. We've been thwarted by the city. In fact, we had Mr. Green's deposition set at the time that they filed this appeal.
Did you file a notice of cross appeal and raise that as a response point?
No, Your Honor, did not.
So do we consider the fact that you haven't been able to do discovery? Is that before us right now?
No, sir.
Okay. Now, is there some requirement? The general rule of thumb is in taxpayer lawsuits, the taxpayer suing to contest a particular tax has to establish particularized harm. Is there a particularized harm pleading requirement that your clients faced?
Not that I'm aware of, Your Honor.
Is there any particularized harm that we could look for in the record if that were a requirement?
The harm would be that we are not allowed to shop for a cheaper provider.
But is that particularized to your clients?
I would say it is, Your Honor.
Well, what about the person next door to your clients? They don't have the right to shop either.
That's correct.
So the harm, that means by definition, the harm is not particularized to your clients. Have they suffered some individuated, particularized harm that would give them taxpayer standing?
From that standpoint, I would say no, Your Honor. However, no, Your Honor.
Can I ask a related question? How do you square your case with that of Perez versus Turner, which is one of those taxpayer cases that Justice Kelly is referring to? It's from 2019 from our court.
Your Honor, I'm not familiar with that case.
I have a question, Mr. Gibson. Aren't these exclusive franchises allowed by the legislature?
Yes, and we don't dispute that issue. What we do dispute is that the fees charged are unconstitutional. That's what we dispute.
Does the legislature set any guidelines or base rates that can be charged or used? And the point I'm getting to is, why isn't this a legislative type remedy or a voter box remedy as opposed to a judicial remedy?
I can't answer that, Your Honor. I do know that it's our position that the amount charged is an unconstitutional fee. I'm sorry?
Based on what?
based on the fact that there are not the city fee does not represent any type of services that the city renders. In other words, they're charging a fee that doesn't have a corresponding service that they're charging.
Does the income tax, say a federal income tax, have or a sales tax? The city levies a sales tax. What service is the city providing? There is a requirement there be a quid pro quo for a fee or a tax, or is it just a fee?
My understanding is that a tax, which the city charges as well at 1.5% on the invoices, is by legislative authority. The fees are not, in the sense that the city chose 25%. They went from 10%, not to 12 or 15, but to 25%. What was that based on? Then they go back down to 15%. What was that based on? Is there no basis? There's no foundation for the city to have a reasonable basis for charging what they charge?
Well, if you go hunting, you pay for a duck stamp and a fishing license. Does the state have to provide me services in exchange for that, the fee for a hunting license?
Well, if we're talking about a hunting license, the last time I bought one, I didn't pay over $1,000 for it. But what that does is that pays for the administration of issuing that license. It helps pay for the wardens that enforce that license. And there's a basis for that. But when you're charged $1,300 a month for pickup of garbage from a third party, what's the city doing to warrant that? That's $16,000, $17,000 a year. That's one of the complex.
Then why shouldn't your clients, rent a billboard? I don't know if there's a petition process or vote out the city council. If they feel that the city council is ripping off the commercial users of waste management, why not vote out city council? Why is the lawsuit the proper remedy instead of, let's say you only charge 1%, and someone wanted thinks it actually should be 10%. Can they bring a lawsuit to get it raised? What I'm having trouble with is why this is relevant to, why this is subject to a judicial remedy and not democratic felicitatory remedy.
That's a good question, Your Honor. It's our position that when a fine or a fee is exorbitant, that you do have a constitutional remedy, and that is that cities, government cannot charge an excessive fine, fee, or tax. And you guys deal with constitutional violations. That's within your parameter. That's within the trial court's jurisdiction. And that's what we're saying, is we're simply saying this is a fine, a fee that violates the Constitution. And that's a redress we can lay before the trial court and say, we need your help. When it's all said and done, the trial court may go, oh, there's nothing wrong with that fee. Goodbye. Okay, then we know. And the city may go, hey, we'll try 35%. We'll try 50%. Let's see where that limit is. And so all we're asking is, court, tell us if this is right or not. Does this pass the smell test? $64,000 question. Why did they stop at 25%? Why not 50%? Why not 200%? Where do you draw that line? What's the remedy? Do I have to go to the legislature and say, please, please, please? What if they say no?
Let me ask a question. You've talked about 10%, then to 25, and then back to 15, and who, what, why, did this happen? Did I kind of infer from what you were saying, the 10% didn't appear exorbitantly unconstitutional, but there's some line in the sand where 25% is and 15% maybe or maybe isn't? I mean, where is that line drawn from your client's perspective?
Our line would be drawn at 1%. And of course, I'm being facetious, Your Honor. The danger is not the minimum. We don't deny they're entitled to a fee. There's no denial that they can get a franchise fee. The problem is, in my mind, is where do you draw the line at the top of that? And this is a really good way, easy way for the city to fill its coffers. The money they collect goes in their general revenue account. This is money that they can collect that's not governed by the legislature with respect to like taxes are governed by the legislature. And it's all across the board as far as what cities charge. But the 25%, when Mr. Losa gave his deposition, that's like at the max. And the question is now, where will the max be next year and the next year and the next year? And at what point are we paying 100% to the city as a way to make revenue?
Well, by the same token, Texas is open for business. It advertises itself nationally as a low tax state in order to draw business from California. So why can't League City say, look, our waste management fee is only 10%, so move from City of Pasadena over to League City? I mean, it's
sure they could do that, but does that make it constitutionally correct? Is that an exemption to the Constitution? I would say no.
It seems like there are other remedies other than a suit for which you may not have standing. And the taxing authority, the fee levying authority, is granted by the state to the home rule cities. And if every tax and every fee were to be subject to challenge in the courts, then the city attorney's office would have nothing else to do other than defend these taxpayer lawsuits or fee payer lawsuits. So I'm still having trouble with the standing and what separates this fee from any other. Are there any other questions from the panel? All right, thank you very much, Mr. Gibson.
Thank you.
Mr. Helfand, you may proceed.
Thank you, Your Honor. Perhaps in light of Mr. Gibson's, well, I'm looking for a word better than confession, but acknowledgement that the appellee's position is that the trial court could deny the plea based solely upon allegations in the petition. Perhaps this is easily disposed. That is absolutely incorrect, since the Texas Supreme Court's decision in Bland Independent School District versus Blue, in which by the way is cited at page 14 of the city's brief, the Supreme Court said, and I'm quoting here, "A court deciding a plea to the jurisdiction is not required to look solely to the pleadings, but may consider evidence and must do so when necessary to resolve the jurisdictional issues raised." And in Bland, the Supreme Court was addressing the very assertion that the appellees here are making. We can just make bald allegations of a waiver of immunity, and the government cannot demonstrate the falsity of those allegations for purposes of demonstrating that the plaintiff has not carried what the court knows is always the plaintiff's burden to disprove the heavy presumption of immunity. There appear to be more than 30 cases in which this court has, by the way, recognized in accord with that clear Supreme Court holding. The most recent is Coogan, C-O-O-G-A-N versus Office of the Attorney General, which is cited at 2020 Tex App Lexus 9549. The opinion was actually written by Justice Landau. I didn't look for that. It just happens to be the most recent opinion. But at page *6 of the opinion, what is listed as headnote 4 by Lexus, the court, Justice Landau's opinion actually quotes the very thing I just read. I also feel like I need to speak to to the appellee's counsel's assertion that they were somehow denied discovery. The record shows that this lawsuit was filed on April 27th, 2018. The city filed its plea to the jurisdiction on May 25th, 2018, less than a month later. The trial court did not take up the plea to the jurisdiction until March of 2020, almost 2 years later. The appellee was not denied discovery. The assertion that the plaintiff is
Mr.
somehow,
Helfand, let me ask one question. Sorry to interrupt you.
of course, Your Honor.
But once the plaintiff has asserted in his petition, okay, this tax is unconstitutional, what type of evidentiary burden does he have once you raise your governmental entity, and how is that asserted?
That actually leads me to exactly what I was just going to say, Justice Hightower, and that is that, and I think it might have been Justice Kelly's question, or it might have been Your Honor's. All taxes appear to all of us to be too high. We rarely hear somebody say, this is a really good tax. I like this one. It's appropriate or low. So simply pleading that a tax is too high is obviously not sufficient to challenge the tax. And I think this goes back to Justice Kelly's question at the very outset under the Nivens case, that simply alleging that a tax is too high is not sufficient. And if it answers your question, Justice Hightower, here, respectfully, that isn't even the question, because this is not a tax. This is a statutorily authorized fee. And I think, Your Honor, Justice Hightower, I think you're the one who asked the question, has the legislature set a cap on that fee? The answer is no. But to bring back the answer to your question, Justice Hightower, to the facts of this case, again, the record is undisputed that the city actually does undertake a good deal of work in the administration of this contract. It's required to inspect all of the waste management vehicles. It has to supervise and address disputes and complaints between customers and waste management, and to enforce the contractual requirement as necessary and as, again, authorized by the statute. That's all at 98 through 105. So I think the answer to Your Honor's question, Justice Hightower, would be the appellee should have done discovery to determine whether the city actually does incur those fees. But again, what the appellee knows and what the record demonstrates without refutation is that fee is imposed upon waste management, not upon the appellees or any other subscriber. I see my time is up and I don't want to continue without the court's permission.
Any further questions from the panel?
Thank you, Mr. Helfand, and thank you, Mr. Gibson. Case number 01200287-CV is now submitted, and the First Court of Appeals is now adjourned. Thank you again.
Good day.
Thanks.
And I'll see you all in 15